You're listening to the Valley Current.
And that was, all of a sudden I realized I'm back at full time now, but I can do it any place I want to be. So that makes it easy to have this type of practice.
Now, is the National Academy of Distinguished Neutrals, are they providing any platform support, or are they just sort of a marketing organization?
They provide the calendar. So if you click on, member directory, you can look up a particular state. And this is where it's so important to me and others. You click on Arizona, for example. Yeah.
Right.
And now this will tell you all the mediators. You can look up their bios, and you can go to a particular day and see what mediator is available.
Okay. So they provide a really simple way to get to a distinguished neutral, which is there's your picture.
Yeah. And so that tells you what my calendars in February are all blocked.
Mm-hmm.
Now, it gives the bio, and you have to keep up with this. And one thing, if you do not work this calendar, after 10 days, NADN will shut it down and say, you haven't checked your calendar. They want you to keep it up to date. So a paralegal at a law firm, for example, or a client of a law firm wants to hire you, they know they can do it on a certain day. They go to that date in Arizona and see which mediators are available. Then they talk to their local counsel. Well, we like this guy, we don't like that guy, and they can pick.
Mm-hmm.
So, it shows I'm starting, and I do half days. So you see the PM, for example.
So when you get this calendar all booked the way you're doing it, you don't even necessarily know if it's a case that you're going to like or dislike. It just sounds like it's a case that floats in, right?
Right, it does. And they contact me, and it goes to the paralegal from ADR support, who also works with the NADN.
Mm-hmm.
Makes the contact, gets all the biographical information that's then sent to me. I review it. And at the same time I'm reviewing it, they're also sending out my confirmation letter that's crafted to my practice. So my confirmation letter goes out. If I want to be paid in advance, it'll say that. If not, I'll tell them how I'm going to bill it and when it's going to take place on Zoom. And she'll send the Zoom link at the same time as the confirmation.
Mm-hmm.
We don't do any paper. Everything's by email or attachment to an email. So everything, there is no paper.
So they're providing kind of a bit of marketing and calendaring. Then that gets handed off over to your back office support at either New Era or ADR support or whatever you're using at the time.
Yeah, New Era works with NADN, but not as, but they do. Mm-hmm. ADR support is, I think, one of the investors in ADR support is NADN. So they were behind creating this. So they work very closely.
Oh, that's
so they manage my calendar. For example, I used to, before I was with ADR support, if I wanted to take off to go to a doctor's appointment, for example, I would do it myself on NADN's calendar. Now I just tell the paralegal, block this day, half day, so they control the calendar, so I don't have conflicts all the time.
Mm-hmm.
Yeah.
So is there a bigger organization behind National Academy of Distinguished Neutrals? Is it part of the AAA, or is it a different group?
It's different. It's set up by a guy named Darren Lee. I don't know how many years ago, probably less than 10 years ago. He's the executive director of this. And I think I'm paying $80 a month for these services.
Mm-hmm.
They provide the calendar and I don't think what else, and a lot of best practices stuff. They also do advertising for you in the local law journals, et cetera. That's also part of their monthly fee from NADN. They also, like I say, provide data to support us nationwide on what we're doing. It's a good idea because it's not telling you how to do it. It's just saying they only take so many in at any one time. I think the number was around 1,200, maybe 1,300 nationally and in Canada. You have to be
not internationally yet.
No, I think that has to do probably with some laws in various locations.
Mm-hmm.
Now, if you're nominated, he has a selection committee of mediators and arbitrators in each state or in each province in Canada. If you're nominated, they have to vet you, and you're vetted both by the plaintiff's personal injury bar or the plaintiff's bar and the defense bar. And that's how you end up getting in there. They run your name out to various people.
Right. So it sounds like it's very much driven around the historical model that the lawyer is tied to a particular bar admission or practice state. There are some lawyers like me that are admitted in California, New York, Florida. I don't know how they handle that. I'm sort of curious because obviously in a federal practice like a patent litigation or copyright or trademark or even now trade secret, all federal statutory regimes, you can do that anywhere throughout the United States, fundamentally.
Yeah, I think if you can list it, you list the bar admissions. And for example, I'm admitted in Arizona and DC. I list both of those on my EDN. So as I'm finding out, for example, the people that want to hire you would look at, say, okay, we want to hire Jack Russo, and we know he's okay. So these are the days that are available to him. We know we want to hire so and so. He's in Atlanta. Okay, they can take a look at both of you to see what your available dates are. Right. And I'm finding once they get a date, the lawyers, at least in Arizona, once they get a date that's open, then they have their pick of, say, 6 or 7 that are available on that particular day. They have their preferences based on our background. Mine was, I think, selected because one, I'm a retired judge. Secondly, I was on the complex litigation court. I've also have some federal practice, both civil and criminal. And I've been around a long time. People just know
Right. It's interesting because I see the way they do their search, and their search is not about subject matter area. It's just about, who you want, and or it doesn't look like it's sort of tied to topic or subject matter. And when case experience, okay, here's case experience. So if we say case experience, I just want to see what it pops up, just to sort of, I'll just put in internet or intellectual property. That's a more interesting one. Oops, wrong term. I mean, it's an interesting thing because this is what I think a lot of people want to imagine, that they're not educating the neutral.
Exactly.
On table. So they come up with 418 people out of like 1,200, I guess, that you say are on here.
Yeah, I think that's roughly it. So you can see where a lot of different jurisdictions. So you can do not only by state, but by skill set or preferences. Yeah.
Right. It's interesting. So to my way of thinking, this is sort of where someone would go, assuming that they want to be, it's interesting, geographic proximity, that goes away if you're doing the practice that you're doing. That's kind of completely irrelevant, right?
Yes, it is. And if you notice by each of those names, there's a little icon for a video camera. Did you see that?
Right, I saw that. Yeah.
You have to be qualified. And the people that took the training course that myself and Lynn Cole and Susan Guthrie did, or NAPN back in 2020, that's how they got that little icon.
Right.
They're skilled, I think. Now, you can represent it. Yeah, you've had training in Zoom. You're available to do it by Zoom. It may have changed the Zoom availability. Yeah.
So is more of your marketing in this fashion, or is more of your marketing just word of mouth? Because I think that's probably a big topic that most neutrals want to try to understand more and more, and who's going to support the marketing, right?
I think it's word of mouth. Now it's changing a little bit. It's word of mouth. There'll be a partner in a law firm. And I do a lot of work out of California, Utah, and New Mexico because of the proximity to Arizona. Partner law firms say, well, take a look at Fields and Smith and whatever. And they give it to an associate. The associates are going to be, or younger parties going to be doing most of the work. So those people are a lot more skilled in technology. They will pick me over somebody else because of my ability to manipulate the technology. I just had one recently. That was the first thing out of their mouth. We had a Zoom meeting with lawyers. I do very little work on the phone, but we had a Zoom meeting with lawyers. First thing is, do you want paper? And I said, absolutely not. They said, thank you, because the last one we've had for 2 years, it was a weird situation. I had to be a special master for federal courts, as well as make it decisions like an arbitrator on the discovery disputes, as well as being the mediator.
Ouch.
And they wanted somebody that did not want paper. And the other guy wanted everything in person and paper. And they said, no, that's not what we want. We want paperless, and we want online. And if we want an in-person meeting, we'll let you know, but no. So they switched after 2 years. It was, yes, an incredibly complex case. Don't know much about it except I don't have a conflict, and it's a construction dispute of some type.
Now, let me ask you: have you ever ended up with a case that you kind of wish you didn't take, and you kind of made your way through it? You have to name names and identify the culprit, but this is sort of the interesting question that sometimes people wonder about. Yeah. You're not really selecting your cases, and I know as a judge, you didn't select your cases either. But there are some cases that are more problematic than other cases. I mean, what has been your experience over the last 15 plus years?
Usually, you'll get into them occasionally, not a lot, because there'll be a problematic client or a problematic lawyer. The one I'll always remember, and I'll tell you, and I'll have to use some vulgarity to explain it. In the case,
okay. It's okay.
It was a very rich client of a very posh, sophisticated Scottsdale law firm. Mm-hmm. Lots of money. It involved some property disputes. He was also a lawyer. Okay. And he was very proud of his Irish descent. Okay. So we're 9 or 10 hours, and I'm in a conference room. This is an in-person one going back a few years. And he's arguing with me about something. And I said, you know what the biggest problem in this case is? He wanted me to go in and build a fire under the other side. You know, you're my mediator. And I said, well, that doesn't mean I'm going to do what you want. And I finally said, you know what the biggest problem in this case is? The impediment to settle? What's that? You're an effing asshole. He looked at me. His lawyers, I thought, were going to pass out. Their eyes about this big. He starts laughing and said, you're right. I'll take the deal. You buy the Guinness tonight. I said, we got a deal. So, and we've been friends ever since. I mean, personally,
maybe the way you delivered it made it sound like he was actually should be complimented. Maybe was the delivery in a positive spin or a negative spin? I mean,
he was, and I was arguing with him, and I thought, no, wait a minute. I just need to put you in a box, and right. I did. I thought the lawyers were going to completely. They didn't know what to say. They thought this was inappropriate conduct, and it was, but I felt it was appropriate at the time.
But I think you can do that these days face to face, and you probably can't do that over Zoom, right?
Not really. Yeah, you wouldn't want to.
Over Zoom, you could really end up with a lot of screens turned off the minute something like that happens, right?
Yeah, and I did have a situation where the client, again, who is a very wealthy lawyer in a construction dispute, he had found some way of getting into my preferences and recording mediation.
Wow. Okay.
Stop it, go back out, and turn off the ability for anyone, including myself, to record the session.
Right.
Because I found, and I've forgotten I'd turn them off, because sometimes I found it was easier at the end of a mediation. It's incredibly complex, is to bring all the lawyers, the parties into a room and turn on the recorder, and it can memorialize the settlement because it was so complicated.
Right.
But I want to get something down right now and before the buyers are more sad. So,
are you using tools that are out there now, like Phantom? We have it running, and I'll show you the results where it actually gives you a bit of a transcript right back.
Because I turn off all my recording and stuff like that. I have not used the simultaneous translation or interpretation with Zoom has the Zoom business model. That's the other thing. When you switch over to ADR support, I went from Zoom Pro to Zoom Business.
Okay.
And I think you had to have a 10 or 20 licenses at $20 a month a piece for Zoom. For one person operation, I didn't want to do that. Even though they were managed to Zoom Business. So that came with the ADR support Zoom.
Oh, that's good. So what's the difference when you get from Zoom Pro to Zoom Business? What actually happens?
It doesn't cut you off after 24 hours. I think you have more people on if you need them. And I'm understanding you can get the simultaneous or contemporaneous interpretation. So if you have an setup. And a few times I've had to do it, I completely forgot about it. So I had the interpreter on Zoom. We'd have to stop And I'm thinking, would you just wake up, make a note to yourself to try to use it?
Right.
But I like to practice sometimes a few times before I get in the middle of something with a client, because, they're paying a lot of money to have you there. They don't want you to stumble around.
What would you say has been your longest mediation in duration, like the date it started and the date it successfully or unsuccessfully ended? I have one right now that has literally gone on for over a year and maybe is going to hit the 2-year mark, but their parties are still engaged with each other. It's an amazing story. It's a complex situation, and there's probably been like 20 different drafts of different settlement documents for enabling a global settlement. But I, in my experience, find that to be like the outlier. Most mediations, I know some mediators that say, hey, if I can't get it done in 4 hours, the case can't settle, but you'll know in a half day, it's worth a half day to try. But you can sometimes have some of them that go on for a fairly lengthy period of time. What's your story on that?
I tend to agree. I think that the outliers, I've got most of mine settle, even the complex business ones, settle within 4 to 5 hours, maybe 6 hours.
Okay.
With an understanding, and I've built it into the draft agreement, that you understand there are additional documentation that has to occur with drafts. So that happens, but I end up with a few that come back to me. We've agreed on everything. They'll also build into this, and I'm getting this a lot. Almost every mediation I do now, they want me to be the arbitrator of the terms.
Oh, if there's a dispute down the road.
And I think that a lot of times with competent lawyers, very good lawyers, sometimes the lawyers and the clients just blow past something. Now, what you're asking me to do is fill in the blanks. I'm completing your contract of settlement. Do you want me to do that? Because I've had a lot of private conversations. I think I understand what you want, but you're going to be bound by me who completes that contract. Usually they say yes, or no, wait a minute, it's not what we had in mind. I said, well, that's kind of what you're asking me to do.
Right.
Or you could just say, this is what you intended by this term or phrase. Usually the more sophisticated clients come like, I think we trust you. We want you to complete this for us. You know what we want. And I've just had one of those that took about 3 sessions over the release. They agreed on everything else. It was kind of a complicated employment, a non-compete intellectual property type when they terminated a person. But I brought them back to the arbitration, but I listened and said, this is what I'm thinking. This is what I think you both should do. This is why. And they both agreed. So I didn't really have to arbitrate it. I just thought that I was kind of reading between the lines, saying this is kind of the way I'm leaning, kind of like I used to as a judge. And then I've got one now that I think we're in the 3rd session. We're coming back. There've been a series of motions that had to be decided by the district court judge. I got another one for 2 years before the judge ruled on some motions for summary judgment. And so we had 2 sessions, but we just couldn't get past that until there's been some rulings. I mean, they agreed on basically a lot of things, but just not the ultimate.
So let's spend a couple of minutes talking about the Center for International Legal Studies, because we're doing a big seminar. They put on seminars typically in different locations overseas. The next one is in Salzburg, Austria on May 18, 2023. You're the chair of that. It's called Global Mobility in an Age of Constant Insecurity, Technology, Strategies, and Solutions. International Mediation. Okay, so I thought they were connected. But it literally has the names of the different people that are doing it, and or at least the people that are registered. I guess I'm not registered yet, so my name's not down there. I guess I better get that done. Ouch. And then there's a schedule. There's a draft schedule that kind of shows what's being put together by the joint chairs, which is you as well as Claudia Calori, as well as Michael.
Yes, Simon Bonet. Yeah.
Okay, so you see it's first day, it starts in the afternoon. Is that right?
It does, yes. And it'll be, it's in May this year.
Right.
Takes place.
It's in person. It's not done at all. It's not done at all by Zoom, right?
Nothing on Zoom. They did not want to go to that model we've discussed with them doing some other things. I wanted a new era and ADR support to maybe if they couldn't show up in person to do a little video, we could start off the one on business. And right now we're still kind of playing with that because there's an Israeli mediator from Haifa that's going to talk about mediation as a business for clients to build into their contracts, as well as how mediators should do kind of a business. Yeah.
Right. Yeah. So there's a networking lunch on Saturday, and I'm the chairman doing the mediation changes brought about by technology. We've talked about a lot of them. I'll bring to the table a number of others, including how ChatGPT is going to play a role in a number of cases, I think, in kind of a orthogonal way to the story. And then the thing wraps up in the concluding dinner and piano concert. It's one of the greatest things to get together with colleagues in a great place like this, such a beautiful place.
The thing itself, it's a gathering of practitioners in mediation, people that are interested in it. It's not learning any basic skills or even intermediate skills. It's an exchange of ideas between peers on where are we going, where do we want to go, and the learning is synergistic, as you know, among peers. You learn by listening, discuss.
Right. It's an intimate group that really does use the in-person approach, and they're not really open yet to bring in a whole Zoom. I've suggested them that they should record sessions and then charge a fee for people that want CLE or whatever in whatever area they wanted. That seems to be the new marketing approach. If you look at what JAMS and AAA and ADR services are doing, they're offering free CLE to get lawyers to sort of know that, hey, our neutrals actually are experts in different areas and can deliver CLE as a CLE provider. So we see how, there's movement happening in lieu of marketing that's more salesy into more content-based delivery of important, valuable CLE that people would often spend thousands of dollars to get. And now it's free. So I don't know what's going to happen to all those paid CLE providers. They must be up in arms that this is happening.
They are. Nancy Flatters, who's a retired Canadian judge, is going to be there. And she was working on this a couple of years ago. The last time we were in sales 2019, she was talking to Lynn Cole, she has Bridges Academy. She's been doing online training for diversity, mediation, et cetera. And they were talking about putting together these blogs, if you will, of discussions and special skill training for family and others. So, yeah, I mean, there's, if I was ever reincarnated, I wouldn't want to come back as a lawyer. I'd want to come back as a computer person. I think the world is unlimited possibilities in this new world. And I wish
Well, you come back as a mediator who is computer enabled. So you come back as someone that can build the next expert system to solve the 80% of the cases that more or less can settle in an automated way. And then the 20% that are really complex and interesting and require a lot of creativity, that's going to be a human being. It's going to be hard to imagine an eBay-like system. There's a lot of online dispute resolution that happens almost magically with no human being intermediating. And that's probably 80% of the disputes that are out there when you look at disputes in the broadest definition of dispute.
Well, eBay and Amazon, but because that's when I was early on working with some of the software engineers, I wanted something where the lawyers could fill in the blanks and within 15 seconds or less, get back a confirmation letter from me, date, time, place, what you need to do. And we're still working there. It can be done, but I didn't want to pay the cost, because the engineers wanted a certain percentage of everything that was booked to me. And I said, no, this is my idea. I want to create it.
Right.
I'll pay you for a while, but it's not going to be a lifetime journey for you.
Right.
So yeah, tons of possibilities.
I mean, I wonder whether, and there must be some computer simulations that the Department of Defense has that say, how is this Ukraine-Russian situation likely going to resolve, and runs all these simulations over, worst case, World War III and a nuclear strike and retaliation.
I'm not giving away any secrets because it was almost 30 years ago, but the first Gulf War,
Yeah.
The two four-star generals basically gave a napkin that they had drawn out some sketches on, brought it to Fort Leavenworth, and the Fort Leavenworth whiz kids at the time, they're all majors, ran all of this like 80 different scenarios on a computer. And that's what First Desert Storm was all about. 100 hours from beginning to end in a victory. Mm-hmm. And that's, yes. And I think you getting inside that decision cycle. So you know what the opposing party's decision is going to be before they make it.
Right.
That's where mediators are going to have to be. Lawyers will be there before us, I think. But some mediators are going to have to say, okay, this is where we're going. And you know that now. You know if a case settles generally what it is. You just can't tell them what it is.
Right. Right. But you have a sense and an intuition, a second order thinking that can say the if then else, if then else, if then else dynamic exchange, like a set of chess moves, counter chess moves, and so on. Like people think that Putin is a master at this, and they think, he's planned this out 16 steps in advance. I don't know if that's true. And it just seems as though I don't want to get political in this, but it just seems like no one has actually painted the computer-based scenarios from absolute best case to absolute worst case in any way that's been very descriptive, at least for my reading of various newspapers. But it seems like they must have some internal versions that describe what can play out here in different
Well, a lot of planners get trapped by their own brilliance. And we used to call it, don't ignore the branches or sequels, because a plan falls apart upon immediate execution. So you have to be prepared for what's going to happen afterwards.
Right.
And what if it goes this way? What if it goes that way?
Right.
So ignoring it because you've got this great idea that you're going to make happen, that you're going to ignore all the possibilities and you will lose. And I think as a mediator, you have to know, for example, when to start bracketing. When you get it close enough, okay, I'm not going to tell them what I think is going to happen here, but maybe we can discuss some brackets to kind of put them in that boundary. And the client, I usually tell, this is where the real decision making starts, the tough. Get down to the real boundary. So now we've bargained. Now we know where the boundaries are. So now we can start the tough negotiations. So, but I think as a mediator, when do you make that move and be aware of it, the branch or a sequel? What's going to happen afterwards? Have you thought about that?
Right. And that's where there's just a human element that can't be easily programmed. Although I think they're going to try as best they can to program as much of this stuff in as they can, with a view that there's a feedback loop that a human being can be involved in that creates, intelligence augmented as opposed to artificial intelligence, IA instead of AI, which is probably what we're going to see over the next decade more than anything else.
Yeah, I agree. And I think you're, as a human, those computer solutions can be a stimulus to say, okay, we're not going there, but this is what I think.
Right.
Okay, I like 30% of it, or it gives me an idea. Maybe we can go in the opposite direction at this time. Right. Because the circumstances have changed. Right. So it's a stimulation, I think, that's part of it. And computers and working with them and solving the problems definitely stimulate your brain to get things going.
Absolutely. So, Ken, you've been great, and this has been great. I'm going to send you the recording. I don't think I would edit anything, frankly, but you decide what you like and dislike. I thought this was a wonderful presentation over the hour or so that we've taken, which is twice what we thought it would be, but it's worth it because in my mind, there's a lot of value here for CILS. There's a lot of value for hopefully your own practice. And there's a lot of value for various participants. For my money, I'd almost say every one of the chairs should come on maybe a shortened version of what we did, just to get introduction of who are you, what have you been doing, how do you see the world of neutrals.
I think it'd be a good idea, and I wouldn't edit it either. I don't know why anybody would want to listen to me ramble on.
Oh, are you kidding me? You're great, Ken. You're a wonderful speaker, and you've got a lot of experience. So have a good day. I know it's the end of your day there in Spain. Enjoy it. Have a cocktail.
I will. All right.
Have a good time. Take care. Bye-bye. Bye.
Tune in next time on the Valley Current.